This is part 39. In the last part, we dealt with the provisions regarding the right of private defense, and in order to understand the right of private defense, we classified it under two different heads. One, the right of private defense of the body and the right of private defense of the property. At the time of discussing right of private defense of the property, we had dealt with section 103 of the Indian Penal Code. And if you have not forgotten, section 103 of the Indian Penal Code deals with the situation where the right of private defense of the property extends to the causing of death. And then I had drawn your attention to the provision that as a student learning Indian Penal Code or any law, you have to take into consideration the amendments that are carried out. Now, if the amendment is carried out by the state government, if the amendment is carried out by the central government, if the law is amended by the central government, that becomes applicable to whole of the India. But if the amendment is carried out by the state government, that becomes only law of that particular state. So it's not necessary as a student of law for you to know the provisions or the amendments which are brought about by all the states. But then when you are in a particular state, I personally feel that because you can't know every amendment which is carried out by every state, but when you are for example, when you are in the state of Maharashtra, you must know the amendment that was brought about in the year 1971 as far as section 103 is concerned, to which fifth clause, there is fifth clause that has been added when the right of private defense of the property extends to the causing of death. If you are in the state of Karnataka, you must know the amendment that is brought about as far as in the year 1972 is concerned. Or if you are in Uttar Pradesh, you must know the amendment that is brought about in the year 1970. So this is, when you read the section, you have to read the section along with the amendments accordingly. And this, as far as the procedure regarding amendment is concerned, the time for you to refer to Article 246 of the Constitution of India. When you deal with Chapter 11 of the Constitution of India, which deals with relations between the Union and the state, and Chapter 1 deals with legislative relations, and it talks about distribution of legislative powers right from Article 245 onwards, out of which Article 246 lays down subject matter of laws made by Parliament and by legislature of states. And it says, subclause 1 says, notwithstanding anything in clause 2 and clause 3, Parliament has exclusive power to make laws with respect to any one of the matters enumerated in list 1 in the 7th schedule in this constitution referred to as the Union list. Subclause 2 says, notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of a state also have power to make laws with respect to any one of the matters enumerated in list 3 in the 7th schedule in this constitution referred to as the concurrent list. And subclause 3 says, subject to clause 1 and 2, the legislature of a state has exclusive power to make laws for such state or any part thereof with respect to any one of the matters enumerated in list 2 in the 7th schedule in this constitution referred to as the state list. And the 4th clause says, Parliament has power to make laws with respect to any matter to any part of the territory of India not included in the state, notwithstanding that such matter is a matter enumerated in the state list. So the time for me to draw your attention to 7th schedule, and then if you start reading 7th schedule, firstly it has got list 1, which is what is known as list 1, which is what is known as Union list, where 97 matters are enumerated. and if the nature of the law falls under any one of the 97 matters which are enumerated as far as list 1 is concerned, then as it is a union lead, the power vests in the central government to make the laws accordingly, and as far as the enactment of the laws is concerned and amendment to the laws is concerned. When you read list 2, it is what is known as state list, where 66 matters are enumerated, and if it falls under any one of the matter, the power vests in the state government to make the laws accordingly or amend the laws. And then lastly, if you refer to list 3, which is what is known as concurrent list, the power vests in central government as far as state government with respect to 47 matters which are enumerated. It's a question of enumeration, and hence as far as the list 3 is concerned, which is what is known as concurrent list. Now when we talk about, as far as matter 1 is concerned, it says criminal law, including all matters included in the Indian Penal Code at the commencement of this constitution, but excluding offences against law with respect to any one of the matters specified in list 1 or list 2, and excluding the use of naval, military or air forces or any matter armed forces of the union in aid of civil powers. So now this is, as you learn this, this is what is known as, you must simultaneously have approach to know the rest of the provisions of the law. So your understanding of the law becomes very clear as far as this aspect is concerned. With this now, I shall start now dealing with one section, namely section 95 of the Indian Penal Code is concerned, as we have started dealing with the general exceptions. And the simple illustration, Mr. A takes a small piece of chalk out of B's possession without B's consent. What is A's liability? Now technically speaking, this has got reference to what? This has got reference to section 378 of the Indian Penal Code. And what is section 378 of the Indian Penal Code with which you are dealt? That defines the offence of theft. Now when we were dealing with the offence of theft, we have learned that one, theft can be committed with respect to movable property. Property must be in possession of some person. He must move the property out of the possession. He must move the property without the consent, and his intention must be dishonest at the time of moving the property. Now in this illustration, all the ingredients are fulfilled. A has taken a small piece of chalk out of B's possession without his consent. Technically speaking, all ingredients of section 378 of the Indian Penal Code are fulfilled, and if this matter goes to the court of law, what is liability of Mr. A is the question. Or A takes a pin, small pin out of B's possession without asking him, and uses the same pin. What is A's liability? Or A, while getting into the bus or getting into the bus, has to push somebody in order to get into it, and then technically speaking that results into bodily pain, and his liability may be for the offence of voluntarily causing hurt defined by section 321 of the Indian Penal Code. In day-to-day life, you are bound to come across such a situations, and hence what is the liability if this matter goes to the court of law is the question for our consideration. And the answer is yes, all ingredients of section 321 may be fulfilled. All ingredients of section 378 of the Indian Penal Code may be fulfilled. But he is not liable because his case of Mr. A falls under section 95 of the Indian Penal Code. And what is section 95 of the Indian Penal Code? The heading of the section is act causing slight harm. And what it says, nothing is an offence by reason that it causes, or that is intended to cause, or that is known to be likely to cause any harm, if that harm is so slight that no person of ordinary sense and temper would complain of such harm. So if in case of a pin, or in case of a small piece of chalk, or in case when somebody has pushed you when you are getting into the bus. In that case, for example, no person of ordinary sense and temper would complain of such harm, will not take such matter to the court of law. If at all extreme case, if the matter is taken to the court of law, what is the defense that can be raised on the part of an accused person? He can say, yes, I have taken small piece of chalk, I have taken peel, I just pushed him when I wanted to get into the bus, but then I am not liable because section 95 is an exception to section 378. Section 95 is an exception to section 321. And as usual, its wording starts, as far as this exception is concerned, what it says: nothing is an offense by reason that it causes, or that is intended to be caused, or that is known to be likely to cause any harm, if that harm is so slight that no person of ordinary sense and temper would complain of such harm, which is based on the maxim. As a student of law, as we dealt with what actus non facitrium nisi mensitria. Similarly, you will be coming across many maxims, and one more maxim. This section is based on the maxim de minimis non curat lex, and the meaning of this Latin maxim is that law takes no account of trifles. If the nature of the wrong is so slight, or nature of the harm is so slight, that no person of ordinary sense and temper would complain of such harm, the question of liability of an individual doesn't arise as far as section 95 of the Indian Penal Code is concerned. In one case, it so happened a police constable went to his boss for the purpose of asking for leave. That was refused by the boss. Instead of the fact that he tried his best to convince the boss, but could not, and then he gave one blow with the help of the stick which he was carrying, and then went away. When this matter went to the court of law, when he was charged for the offense of many offenses, out of which one was voluntarily causing hurt, and when he raised the stick, that also amounts, I hope you are not forgotten, assault. And when he had brought that stick into contact with others' body, that also amounts to the offense of criminal force. Yes. And what was his defense? He said, my case falls under section 95. What was done by me, this was the harm, it was so slight, otherwise if my intention would have been to cause bodily pain, I would have given him number of blows. I gave only one blow, that sort. And then that argument was negated by the court of law, and court convicted him for the offense, and the court said, well, your case, this defense is not available to you. You can't you blow with the help of the stick and say, well, my case falls under section 95 of the Indian Penal Code. Now, though, as you go on learning the law, let me tell you, you will come across, as far as this section 95 is concerned, you will come across one interesting case. That was publicized everywhere within the territory of India. And the name of the case, you might have also read in the newspaper by that time, and the name of the case is Rupan Deval Bajaj versus KPS Gill. Now, I need not tell you, both the personalities are such that KPS Gill was Director General of Police as far as Punjab is concerned, and this Rupan Deval Bajaj was class 1 IAS officer. And what was the nature of the case, and why we are concerned with section 95 of the Indian Penal Code? They met in one party. KPS Gill, it is said that he was under influence of alcohol, and he patted on posterior of Rupan Deval Bajaj. The matter went to the court of law, and Mr. KPS Gill was accused of section 354 of the Indian Penal Code, criminal force or assault with intent to outrage modesty of a woman, and also section 509 of the Indian Penal Code. These are the sections to which I had reference. at the time of discussing section 375 of the Indian Penal Code, which defines the offence of rape. Person may be liable for the offence of rape. Then we also learned he may be liable for attempt to commit rape, or the person may be liable for criminal force or assault with intent to outrage modesty of a woman. And then in one more section to which I refer to, namely section 509, which deals with word, gesture or act intended to insult modesty of a woman. So Mr. KPS Gill was accused of, as per section 354 and section 509 of the Indian Penal Code. And the defense which was raised by Mr. Gill at that time was that well, this is, slight harm. No person of ordinary sense and temper would complain of such harm, which was negated by the court of law. The matter went up to Supreme Court, and after, this entire law, the final decision was given by the Supreme Court after 17 years. Very interesting. You can go through, and there much literature is also available as far as this aspect is concerned. But this is one case. It's not that that you have to refer to this case only. There can be n number of illustrations which you can take into consideration. And the object of the legislature is that, if these matters are taken to the court of law, for example, what you do, you dip your pen into somebody's ink bottle without his permission and commit theft with respect to one drop of ink. Technically speaking, you are liable. But if this matters, or if somebody is eating wafers, you take one wafer and eat wafer without his permission, in that case, if you take a wafer, that also amounts to the offence of theft. Or you take one wafer crumble and put it again into the dish, yes, that amounts to the offence of mischief as defined by section 425 of the Indian Penal Code. But if these matters, if they go to the court of law, naturally, what is the view that will be taken by the court of law? When the defense is raised that my case falls under section 95 of the Indian Penal Code, the question of liability of an individual doesn't arise. So this is section 95 of the Indian Penal Code, which deals with what? Which deals with act causing slight harm. If you are driving your car and the car goes into a water, by taking the car into the water, if the water is now spreads in such a manner so that the water somebody who is passing by the side of the road. Now, can it be said that, well, this amounts to the offence of criminal force as defined by section 350 of the Indian Penal Code is the question, and hence the court, if these matters go to the court of law, this and then the defense is raised that this falls under section 95 of the Indian Penal Code, the question of liability doesn't arise because of this section, and that is the end as far as section 95 of the Indian Penal Code is concerned, which deals with it says nothing is an offence by reason that it causes, or that is intended to be caused, or that is known to be caused any harm if that harm is so slight that no person of ordinary sense and temper would complain of such harm. With this now I take you back, and then we start now discussing two sections of the Indian Penal Code. Firstly, section 76 of the Indian Penal Code and section 79 of the Indian Penal Code. Now, say out of each sections, clubbing the sections which I have told you at the time of the introduction. Section 76 deals with the cases where the person is bound by law, whereas section 79 deals with the cases where the person is not bound by law, but there is justification. He is justified by the law. There is justification for the act which is done by him. So these are the two sections which we shall be. Mistake of fact can be a defense, but mistake of law cannot be a defense because of the maxim, ignorance of law is no excuse. So that is also the principle. As you want to get benefit as per the provisions of the law, you must abide by the law. You can't say I was not knowing a particular provision of the law. If this is accepted, everybody will start arguing in this manner. As a result of which, ignorance of law is no excuse. And hence now, mistake of fact, there can be a mistake of fact, because there can be, but mistake of law, no, you must know the law, and hence we will take these two sections into consideration. Now, at the time of discussing section 76 and section 79 and some of the exceptions with which we shall be dealing during course of our lecture, mind well one thing, that person is protected provided he has acted in good faith, otherwise not. And then we want to know what is the meaning of the term good faith. Now, when we read section 76, we come across this term good faith. When we read section 79, we come across this term good faith, and many more sections with which we shall be dealing. But what is the meaning of good faith? Now, in order to know good faith, as both the sections or the sections with which we are dealing are silent to explain this term good faith, naturally, what we have a reference back to general explanations right from section 6 up to section 52A of the Indian Penal Code. And then what we learn? We try to understand by reading section 52, which defines what do you mean by good faith. But then this is also the time, if at all you have decided to do homework and you have started doing homework, you come across good faith as far as criminal law is concerned, and you come across good faith as far as civil law is concerned. When it is criminal law, we go by section 52, whereas when it is as per the civil law, for example, when you shall be dealing with the provisions of the Sale of Goods Act, and then you come across a term good faith. Buyer is a bona fide purchaser, he acted in good faith. Now, what is the meaning of this good faith? Whether it is defined by the provisions of the Sale of Goods Act, it is not so. And then what you do? You refer to the provisions of the General Clauses Act, because in case of a civil law, you have to go as per the enactment, namely the Sale of Goods Act. If not, as per the General Clauses Act. If not, you have to refer to any standard dictionary. So here we shall be dealing with section 52. During course of time, as we proceed further, we will understand the importance of it, but that is during the next part. We shall be dealing with section 76 and section 79 of the Indian Penal Code, when we have started discussing right from section 76 onwards of the Indian Penal Code, right from 76 up to section 106, deal with general exceptions with which we will continue our discussion.